All right, we will take up our final case this morning. A few preliminary remarks. I'm presiding Judge Thomas E. Malone. We also have Judge Steve Hill and Judge Mike Boozer on this panel for this case. Let me remind the attorneys that we have read your briefs, so we're familiar with the facts of the case and the very long history of this case. You certainly don't need to repeat all that due to the limited time you have to make your arguments. As the presiding judge, I'll be the timekeeper. You're only given 15 minutes per side on this particular case. The appellants, if there's more than one attorney per side that will be making an argument, you need to decide in advance how you wish to divide your time. The appellant's attorney should let us know at the beginning of your argument if you wish to reserve any time for rebuttal. At the completion of today's hearing, your case will be deemed submitted for decision. And after that, we will get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll call the third case on the docket. It is from Shawnee County. It's number 121046, entitled Hodes and Nauser, MDs, PA, and Tracy Lynn Nauser, MD, versus Ali A. Norman, MD, et al. And who do we have here for the appellant?
May it please the court, I'm Assistant Solicitor General Dwight Carswell, appearing on behalf of defendants appellants.
And Mr. Carswell, your name, or you entered an appearance in this case recently, didn't you?
I did, that's correct, a few weeks ago, yeah.
All right. And who do we have here for the appellee?
Your Honor, Teresa Woody for the plaintiffs, and our argument will be conducted by Ms. Schneller.
Good morning, this is Hillary Schneller for the appellees.
All right. And Mr. Carswell, do you wish to reserve any time for rebuttal?
Yes, I'd like to reserve 3 minutes, please.
That is granted, and you can go ahead and begin.
Thank you. May it please the court, the district court in this case erred in holding that the 2011 agreed injunction prohibited the enforcement of a statute that was enacted in 2015 that made substantial changes to and repealed the prior version of the statute. The district court's error was even more serious given that the plaintiffs don't even have a standing to challenge the new statute. The judgment of the district court should therefore be reversed. KSA 2015 sub 60-4A10 was first enacted in 2015, over 3 years after the agreed injunction was issued in 2011. The district court in 2011 had no ability to enjoin a statute that wasn't even written yet. Courts only have jurisdiction over statutes as they currently exist. And can only.
We're talking about jurisdiction. Let me turn your focus to that. Your jurisdictional grounds to bring this appeal to our court is 60-2102 subsection A2. It allows for an appeal of any order granting, refusing, modifying, dissolving, or continuing an injunction. Please give us your argument as to why this court has jurisdiction to consider this appeal.
Well, you're correct. That's the statute that we maintain does that for two reasons, at least. First of all, the statute talks about modifying an injunction. And our position is what the district court did is modify the injunction that was issued in 2011, expanded it to cover the statute that was enacted in 2015. And that's a modification of the injunction. This injunction as it was issued in 2011 only enjoined that law, not the statute that was later enacted. But at bare minimum, what the district court did was continue the injunction. Our position is that the 2011 injunction does not extend to the law enacted in 2015. The district court disagreed and said, no, it continues to apply. That by the straight plain meaning of the statute is an order continuing an injunction. Now, plaintiffs argue that orders interpreting an injunction are somehow exempt. What you are doing here is statutory interpretation. So you look to the language of the statute, and this is plainly a continuation of an injunction at minimum, not a modification as we believe.
Let me ask you this question. You filed a motion to dissolve the injunction. actually a motion to clarify or dissolve the injunction as to the 2015 amendment.
That's
Let's
correct.
assume for a minute that we agree with your argument that the district court's order denying your motion would constitute a continuation of an injunction. My question is, do we even have that here? What I'm getting at is, did the district court ever even deny your motion? The last I understand, it was left off. The judge wanted to set it for some sort of a evidentiary hearing on the standing issue. And the next thing we know, we get your appeal.
Well, the district court did deny our request for clarification and to dissolve the injunction, and that it said that the 2011 order continued to apply to the 2015 statute, and that's what we're appealing. Now, the district court also wanted us to separately move to modify the injunction, starting with the premise that the injunction does apply to the 2015 statute, and that's what the district court set for a later hearing was questions about that, the merits of the issue. What we're addressing is not
the standing issue, as I understand your argument, is the plaintiffs do not even have standing to challenge the 2015 amendment because they said they were complying with it anyway. Is that right? That's the standing issue?
That is one of our arguments, yes, and that's the standing issue. And the district court on that point said that he thought that was wrapped up with the merits and therefore needed to be considered in proceeding on the merits.
That's the point I was going to make. Isn't that intertwined with the entire issue on whether the injunction should have been dissolved as to the 2015 amendment?
Well, our first point there is that the 2011 injunction doesn't even apply to the 2015 amendments, and the district court held that it did. And that, in our view, is an order continuing the injunction. Now, standing is a separate argument, apart from whether the 2011.
I don't mean to belabor this point, but where it left off was, the last thing Judge Tice did was say, let's set this standing issue down for an evidentiary hearing. That's not the way most cases end in district court. Next thing we know is we have an appeal from the state, and I'm really struggling with why we even have jurisdiction to consider this appeal.
Well, this is an interlocutory appeal, but it's one that's specifically authorized by statute. Here, as we mentioned, KSA 60-2102. And what that provides your court jurisdiction over is orders continuing an injunction, which is what the district court's order did here. The district court did defer the standing question, we believe improperly, saying that was wrapped up with the merits. But the district court also said this injunction that was issued in 2011 continues to apply to the 2015 statute. That's an order continuing an injunction, even though the district court deferred a separate question of standing. And so under that statute, we do have jurisdiction to bring an interlocutory appeal of that. Our point is that regardless of standing, I mean, we don't believe they have standing, but regardless of standing, the 2011 injunction does not apply to the 2015 statute. And that if plaintiffs want to enjoin the 2015 statute, they would need to bring a request to do so and make the required showing. What we have here is a statute that's currently enjoined without any of the typical five-factor legal analysis about whether an injunction is proper over our objection. The district court never made any of those required factual findings, legal findings about plaintiff's likelihood of success, the irreparable injury, those typical findings, and ordered that this statute that passed in 2015 is continued to be enjoined, and that was improper. In particular, given that the 2015 statute is materially different than the 2011 statute. The 2011 statute, plaintiffs' key complaints against that statute is laid out in paragraph 44 of their petition, where that it didn't include a medical emergency exemption and that it didn't include an exemption for hospital-based induction abortions. Both of those issues were addressed in 2015. In fact, plaintiffs submitted their petition to drop those particular allegations. And so we have a material change here. And one other key issue that was changed was the 2011 statute required that any abortion-inducing drug be be administered in person by the physician. The 2015 statute changed that, separating out the drugs. Now it only requires that mifepristone be personally administered by the physician, and that any other drugs either be provided, not necessarily administered, but provided, or the prescription be provided to the patient. And that's key because that conforms with what plaintiffs do according to their deposition testimony. Dr. Nauser testified that she provides the mifepristone to the patient in person, and the patient takes it there in her presence. And then the second drug, they use a 2-drug regimen, misoprostol or Cytotec is the brand name, is given to the patient, who then goes home with it with instructions about when to take it and what to expect and what to watch for.
2011 amendment or statute that got this whole thing going 10 years ago now, basically requires an in-person treatment provider to administer abortion-inducing drugs. Isn't that correct?
That was, yes, what the 2011.
That's the thrust of the statute, and plaintiffs filed their motion to prevent its enforcement and got their temporary injunction. And then along in 2015, the statutes amended to create a couple of exceptions, the hospital exception and the emergency exception. But the thrust of the statute's still there, right? It requires in-person treatment provider to administer abortion-inducing drugs, which is what the plaintiffs were trying to put a stop to in the first place. Well, I guess my question is, if we're talking about the merits of this lawsuit, I understand the 2015 amendment created a couple of exceptions, but the thrust of the problem is still there as the plaintiffs see it. Why wouldn't the 2011 injunction apply to the 2015 amendment? The two exceptions doesn't change the thrust of what the plaintiffs are complaining about.
Well, I would disagree. The 2011 statute, their key concerns with that, again, if you look at paragraph 44 of their petition, were the things that were changed, the emergency exemption, then the hospital-based injunction. In addition, there's the other change I mentioned, which is the fact that now this only requires that one drug to be physically administered in the physician's presence. And the agreement, what happened here, I think it's even, what the district court did is even more objectionable, given the fact that what we have is an agreed injunction in 2011. The defendants agreed not to enforce the statute based on the plaintiff's claims at the time and the statute as it existed at the time. We never agreed not to enforce a different version of the statute that might be enacted in the future. And so given that change, our agreement is no longer valid. And so what the district court needs to do, if this needs to be enjoined according to plaintiffs, is for the plaintiffs to file a motion and make that showing. Do you have a question, Judge Hill?
I do. Counsel, can you point to me in the record an order by Judge Tice that says this injunction continues? It continues in effect. Words to that effect. Or are you construing this, let's take a look at this as an evidentiary hearing, as an order continuing the injunction?
Well, what the district court's order did was twofold. I mean, with regard to standing, it said we're deferring that needs to be addressed on the merits. But with respect to the injunction itself, it pointed back, there's several different cases. There's a separate case called Trust Women, which I'm sure you're familiar with.
No, answer my question, please. What order did Judge Tice issue that says this injunction continues? Because as I understand the statute, then that gives you right for an interlocutory appeal, correct?
That's correct. And it's the order we're talking about that we filed the notice of appeal from after we filed our motion for clarification or to dissolve the injunction. Judge Tice, I don't have the exact record site right here, but Judge Tice issued that order saying that based on what I said in Trust Women 1, this injunction from 2011 applies to the 2015 statute. It was basically an incorporation by reference of the order in the Trust Women case. But what it did was continue the injunction.
So I guess if I hear you correctly, you're telling me there's no explicit language, you're arguing by inference.
I think it's explicit if you read what Judge Tice did. I admit it's not the clearest order, but I think it's clear that his position is that the 2011 injunction continues to apply to the 2015 statute in his view. In our view, what it did was extend it, and he obviously that he doesn't agree with us on that, but what he did believe was happening was that the 2011 injunction still applies to the statute in his view. And so that's what we're appealing from. I'd also like to address the issue of standing before I run out of time. Plaintiffs here, although there's relaxed standing in the third-party doctrine in abortion cases, the ability to assert legal rights that belong to abortion providers' patients, that doesn't relieve a plaintiff of the requirement to show an injury in fact. If you look at the U.S. Supreme Court's decisions in Whole Women's Health and June Medical, for instance, they talk about the third-party standing doctrine, which is relaxed as a prudential doctrine, but the injury in fact requirement's a part of the constitutional requirement for standing. And so that always continues to exist. In those cases, we're under federal law, but the same is true under the Kansas Constitution. The Kansas Supreme Court in the Comprehensive Health of Planned Parenthood v. Klein case made clear that an injury in fact is required for a plaintiff, even in abortion cases. And what happens here is we don't have an injury because when plaintiffs, again, remember back when this case was first filed in 2011, they were not performing medication abortions. They didn't begin performing medication abortions until 2014. At that point, everyone agrees that the statute was enjoined. So they could have used whatever method they felt was most appropriate. But what, according to Dr. Nauser, they've been doing since that time has been completely consistent with what the statute now requires, which is that the patients come into Dr. Nauser's office and she discusses with them at that point whether it should be whether they wish to have a surgical or a medication abortion. And most of them elect for a surgical abortion, but those that choose a medication abortion are therefore already there, and she provides the drugs to them while they're physically present in her presence. And that is
Mr. Carswell, since the 2015 amendments, have the plaintiffs had an opportunity to make a record with regard to standing?
Yes, Dr. Nauser's deposition occurred after that time. And in addition, at any point in response to our pleadings, they could have either submitted affidavits or even just said, we do wish to provide abortions that aren't in compliance with the statute. And therefore we need more discovery to do so.
Am I correct that that is the reason, or that is possibly one reason why the court wanted to have an evidentiary hearing on standing so that that issue could be fully discovered?
Well, the discovery wouldn't take place in an evidentiary hearing. That's something that would proceed on the basis of depositions and interrogatories. And so we pointed to the record as it existed at that point.
Then why did the judge want an evidentiary hearing?
For some reason, Judge Tice thought that was wrapped up in the merits of the issue, the question of whether this violates the Constitution or not. We disagree with that. Obviously, we think that standing is something that can be decided based on what the record as it currently exists. And if plaintiffs have some other argument for standing, they could have presented that either in Dr. Nauser's deposition or otherwise. But the record is clear right now that what Dr. Nauser's been doing according to the record is fully consistent with the statute. All they've said is that, well, at some point in the future, this may be unsustainable, but that's just a hypothetical future injury. There's been no indication of concrete plans to do something different now.
Standing is basically the first question the court resolves in any lawsuit, isn't that right?
I think that's correct. Now, it can be considered a different point.
The judge never even got off first base here. The judge never even decided the standing issue.
Exactly. I think that was error. But if you're going to the question of jurisdiction, we do think we have jurisdiction to appeal this given the KSA 60-2102 and the fact that this was an order continuing the injunction. But Yes, we think it was error for Judge Tice not to address the standing issue.
You would at least agree with me that that's what the jurisdiction issue boils down to, is do we interpret Judge Tice's ruling as an order continuing the injunction?
Continuing or modifying, yes. Our position that it modifies, the at bare minimum it continues.
All right, okay. You're getting into your rebuttal time, so if you still want to have rebuttal, you'll need to yield the floor.
Okay, unless there are any further questions, I will do that. Thank you.
All right, we will turn to Appellee's counsel.
May it please the court, Hillary Schneller for the appellee physicians. This court should dismiss the state's appeal or simply affirm the district court's order for 3 reasons. First, this case is not properly before this court, and the state's appeal attempts to short circuit the district court's work. Second, in any event, the district court did not abuse its discretion in construing the agreed order. It correctly interpreted the agreed order to encompass the in-person requirement as amended. It also set a hearing at which it would separately address a request to modify that agreement. Third, the state has prematurely put standing before this court. The district court, as the court has recognized, did not rule on that question, and again, set a hearing at which it would resolve relevant factual issues. Regardless, given the context here, the state is wrong that the physician's current compliance with the law means they don't have standing to challenge it. So just to take a step back and turn to some key facts, shortly after this case was filed, the state agreed not to enforce any of the challenged laws here pending final judgment in this case. The state has never moved to alter that agreement. In 2015, an amendment passed that slightly narrowed the in-person requirement, but did not change its core in-person mandate. The state told plaintiffs, as well as the district court, that it would move to modify the agreed order so that the amended law could be enforced. Despite those representations, the state, again, has never asked the district court to modify the agreement. Instead, we're here today because the state moved to clarify that the law had already and automatically become enforceable without notice to the parties or the court. The district court here construed the agreed injunction to cover the in-person requirement as amended because the core requirement plaintiffs challenged and the state agreed not to enforce remained unchanged. That order is not one of the limited types of non-final orders that are appealable under KSA 60-2102. Again, no request to modify was made, and there's no modification order to appeal here. All the district court did was interpret the agreed order and set a hearing to resolve relevant factual issues. And a simple clarification or interpretation is not a continuation of an injunction within the meaning of the statutes here. But in any event, the district court did not abuse its discretion in interpreting the scope of the agreed order, so that order should stand. The district court was correct to find, as it did in a related case, that the state's agreement not to enforce still encompasses the in-person requirement here. That conclusion was based on a straightforward application of a rule of construction in Kansas Statute 77-201, that the provisions of any statute, so far as they are the same as a prior statute, shall be construed as a continuation of the prior provision and not as a new enactment. Again, the in-person requirement here still mandates that in nearly all circumstances, a physician be physically present when medication is used to cause an abortion, when medication used to cause an abortion is administered. Because that core requirement remains the same, the agreed order still covers it. So because the district court did not abuse its discretion there, we would ask the court to affirm that order. And finally, the state had also asked the district court to partially dissolve the injunction because it believed plaintiffs don't have standing to challenge the requirement. As has been discussed, the district court did not rule on that issue. Instead, well within its role as the initial fact finder here, it set a hearing at which it would hear testimony and resolve relevant factual issues. before that hearing could happen, the state filed this appeal. This appeal, therefore, has essentially cut off the district court's review, and it would be inappropriate for this court to weigh in on the issue in the first instance, in particular where the district court has indicated a need for more facts. And then I do finally want to address briefly the state's argument that because the physicians are complying with the law currently, they do not have standing to challenge it. Given the state's initial intent here to move to modify the agreed order, and its position now that it didn't even need to do that because the law is currently enforceable and has been since 2015, the physician's current compliance is reasonable. The state's shifting position has meant that the physicians currently operate under a threat of serious penalties from this requirement. And absent a permanent injunction against the requirement, the plaintiffs do not have the same assurance of flexibility in their practice as other physicians do. And that is sufficient to confer standing. So in short, the requirement and the state's shifting positions about its enforceability mean it continues to cause injury, and that injury would be redressed by a permanent injunction. So for these reasons, we would ask the state to dismiss the state's appeal, the court to dismiss the state's appeal, or simply affirm the district court's order.
All right, counsel, hearing no questions, we will go back to Mr. Carswell for your rebuttal.
Thank you.
I'd like to make 2 points. First of all, in terms of how the 2011 statute relates to the 2015 statute. As I noted, the plaintiff's key complaints at the time against the 2011 statute were the lack of an emergency exception and the lack of an exception for hospital-based abortions. And that makes sense because, again, in 2011, they were not performing medication abortions. And so even if that time they had wished to challenge the requirements for just regular medication abortions, they wouldn't have had standing to do that. Their concern was the emergency exception or lack of an emergency exception. And that's what the state's agreement not to enforce the statute was based on, were their concerns at the time and the form of the statute as it existed at the time. So at minimum, if they now wish to enjoin the 2015 statute, which is different, they should move to enjoin the statute and then make the arguments about whether that's appropriate based on the typical 5-factor test. The district court, again, has never made those findings, those legal conclusions about whether the statute should be enjoined in its present form. And then also in terms of whether the medicine has to be administered in person, under the prior version of the statute, their current practice, as explained by Dr. Nauser, would have been inconsistent with the 2011 statute, but it is consistent with what the 2015 statute provides. So the statute is materially different in that respect as well. These are very different statutes. If the district court wanted the 2011 injunction to continue to apply, the plaintiff should have made that motion to do so. Finally, as to standing, they claim that, well, maybe there's a threat of enforcement now, and that's why they're doing it, but they've never said that in any of the deposition materials, interrogatories, anything like that. They've never said the only reason we're complying is because that's what the statute requires. If it weren't for the statute, or if the statute were enjoined, we would do our abortions differently. The only indication in the record is what they're doing now, which is consistent with the statute, is what they continue to do if the statute continues to be enjoined, as they believe it already is. And for those reasons, they don't have standing. There's no injury to them because it doesn't affect how they perform abortions. Unless there are any further questions, I would just urge you to reverse the district court. Thank you.
All right, counsel, thank you very much for your briefs and your arguments. We'll take the case under advisement, get a written decision out to you and your clients just as soon as we possibly can. And so with that, that completes this morning's hearings. Thank you for participating.